Hi, I'm Lee Liberman Otis. I am the director of the faculty division, and on behalf of the Federalist Society, I'm delighted to welcome everybody here to the 15th annual Federalist Society Faculty Division Conference. Um, I am going to invite John McGinnis to say a few words about Judge Bork before we get started with the program, and then we're going to go directly into our very exciting panel. So, John?
Well, thank you, Lee. It's certainly appropriate to remember Judge Bork at the Federal Society Faculty Division because he is really the most important conservative legal scholar of the last century, and we are all his intellectual children. There are two strands to the intellectual movement in conservatism and libertarian thought in the latter part of the 20th century. One was law and economics, and the other was originalism. And Judge Bork distinguished himself by being at the center of both of them. While his obituaries did not much emphasize his law and economics work, indeed the New York Times dismissed it in a paragraph in which he said that he taught a course in pro-trust at the Yale Law School. His work in antitrust was truly revolutionary. The book, The Antitrust Paradox, was an enormous milestone, not only in antitrust, but in law and economics. Because while law and economics ideas have been percolating since the 1950s, what had not happened was a lawyer coming and giving a comprehensive discussion of legal doctrine in terms of economics, of a book length. What Bork was able to do, what Judge Bork was able to do, was bring a lawyer's gimlet eye and marry that with an economist's passion for careful modeling to create a revolution in a legal discipline, antitrust. And that revolution continued for a very, very long time because he wrote comprehensively about antitrust, about horizontal rules, vertical price regulation, monopoly. It really only finished in the Leggin case in 2005 when the Supreme Court, in a decision that I think cites Judge Bork, suggested that vertical price maintenance also should be understood as decided under a rule of reason, and thus finished what was called the Chicago School Revolution in antitrust. I would actually analogize Judge Bork here to a politician, someone like Margaret Thatcher, who completely changes the terms of the debate. People after Thatcher, like Blair, are very much part of the debate and the line she set. And that is true in antitrust. While there are still debates about certain portions of antitrust, Judge Bork's contribution sets the terms of those debates. Of course, he's even better known for his contribution to originalism. And his contributions there are extraordinary. And I think the way to measure their extraordinariness is to look at conservative legal thought before Judge Bork. If one looks at the opinions of Justice Harlan and others on the court that immediately before Judge Bork started writing about originalism, they seem not all that different in methodology from the opinions of the liberal justices on the court. But in his seminal work, Neutral Principles and Some First Amendment Problems, Judge Bork changed that. And he changed that by making a bold and innovative move by deciding that, while neutral principles was part of the legal process school, he argued that neutral principles had to be derived with a neutral method. And therefore, they needed to be derived through originalist methods, at least broadly understood. Now, often it's said that there are many disagreements many of us in this room have with Judge Bork on originalism. I think some of the people on this panel, I'm sure, have some disagreements with the brand and justifications of originalism that he gave. But that, I think, is quite irrelevant, or in some sense is actually a stronger, it shows indeed how powerful Judge Bork's work was. Because Judge Bork was a pathfinder. He went and he created a new chart of law by bringing originalism to understanding constitutional law. The fact that we have some disagreements on exactly where the boundaries in the new world he discovered lie is a testament to the power of his idea and, of course, points up what I think is always true about scholarship. It's fractal in nature. Once you have a map of the world, one can always have a disagreement about exactly the boundaries, meant to make the boundaries more and more precise over time. But it's Judge Bork who made that originalism move in 1971 in a powerful way, which has resonated down to this day. Let me end by talking briefly about Judge Bork's defeat in the Senate and why I think that shows actually, again, the power of his ideas. Because while he was defeated in the Senate, his ideas could not be so easily defeated. That's one of the great things about ideas. They go around political barriers. They seep into society and change it. They're like a torrent of water that bears all before it. And that's really Judge Bork's legacy. Because when we look at an opinion like Heller's opinion on the Second Amendment, that is a wholly originalist opinion, and that is a tribute to Judge Bork. Because what happened, and I think it's again important to measure his contribution by what went before, in 1968, Chief Justice Burger, then a conservative, wrote a denunciation of gun rights in that well-known legal periodical, The Parade magazine. And so that was what conservatism was at the time, a kind of ad hoc flaunting of one's policy prejudices. But what Judge Bork started was a dramatic change in that, a turn to real history and a turn to analysis. And that, as ideas have a way of doing, started changing scholarship right across the political spectrum. Because Heller also reflects the fact that it's not only conservatives who've taken originalism seriously, it's liberals as well. And it's that body of scholarship about the Second Amendment that had an enormous influence, I think, on the Supreme Court. There's one other thing I think one should point out about Heller. While the dissent disagrees with the majority, the principal dissent attempts to be originalist in nature. That, too, is a mark of Judge Bork's triumph, that even as he was defeated in the Senate, he set the contours for what seemed to be possible for a Supreme Court justice to say in that important decision. So, in conclusion, I think one has to say Bork was not simply a great conservative scholar, he was a great scholar. He was energetic and fearless. He painted in bold strokes about important and great things. And he changed the world as much as a force of nature. We are all his beneficiaries, and the only way we can repay him is to emulate him. Thank you very much.
Thank you, John, for that. And we didn't obviously plan this panel with Judge Bork's unfortunate passing in mind, but it really couldn't be a more fitting panel to begin with, to begin our conference with, in light of the remarks that you just made about Robert Bork. Let me just frame what this panel is about. The title of it is Roundtable on Judicial Deference versus Judicial Engagement. I think that this panel is about a very important intellectual issue that is confronting everyone who flies under the rubric of the Federalist Society. There has long been propositions advocated by the libertarian and conservatives within the coalition that is the Federalist Society, and that is a tension between what you might say is originalism on the one hand, the respect and following of the original meaning of the Constitution on the one hand, and on the other hand, the philosophy that is sometimes goes by the name judicial restraint. These are two fundamental propositions that Federalist Society members have long adhered to, but they have always been in tension with each other. They remain in tension with each other, and the recent Affordable Care Act case has sort of revealed that tension to everyone, and it's time that I think we address this tension in a serious manner. Now, there's a very easy way to reconcile originalism with judicial restraint, and it's not going to be the way that any of the members of the panel are going to do that. And one of the simplest way to do it is by definition by saying, look, it's restraint if you follow the original meaning of the Constitution, and it's judicial activism if you deviate from the original meaning of the Constitution, and therefore there really is no conflict, and I do hear this from time to time from people who are engaged in this kind of debate. But that's not really, if any of you know, because all of you know, because you're all part of the same sort of culture, the same sort of legal and political culture that I am in, you know that that's not really what the tension is. The tension is between judges enforcing the original meaning of the Constitution against the legislative and executive branches, and judges exercising restraint and deference and somehow allowing the legislature to get its way because the legislature is thought to have a democratic legitimacy that the court does not have, and thereby to defer to legislatures even when, perhaps, the original meaning seems to go in one direction and not the other. So this is the source of the tension. The tension is indeed a historical one, and this sort of harkens back to the history that John just talked to us about. The conservative and libertarian legal movement was generated in the wake of the Warren Court. It was generated against the Warren Court, whatever the Warren Court stood for. This was a political and legal movement that was generated against that court. And one of the things the court stood for was deviation from the original meaning of the text of the Constitution, or forget the original meaning, just deviation from the text of the Constitution altogether. And the other thing they stood for was invalidating a lot of laws and reversing a lot of precedents. And that was something that people on the right did react against, but many of the people on the right who did react against that were themselves not necessarily what we would think today of as Reagan conservatives. In fact, they were unreconstructed Roosevelt New Deal liberals, like, for example, Raoul Berger, one of the patron saints of judicial conservatism and also of originalism, although he wrote before there was a term called originalism. Raoul Berger considered himself to be a New Deal liberal to the day he died. He told me that personally. He had never been anything other than a New Deal liberal. But what kind of New Deal liberal was he? He was the kind that believed that what had gone before the New Deal was an exercise in judicial activism. The term judicial activism was first coined by Arthur Schlesinger Jr. in a magazine article that was critical of some of the members of the New Deal court for invalidating legislation that they should have been upholding. And so he believed in judicial conservatism in the form of judicial restraint, which meant judicial deference to the legislature. That was how some members of the New Deal coalition had defined the sin of the Supreme Court prior to the New Deal, and they never changed their mind about that. And it didn't matter what the outcome was. They believed that the courts were relatively illegitimate as compared with the more democratic branches, and really either should rarely invalidate laws, or in the case of our good friend Lino Graglia, terrible Freudian slip, it doesn't even apply. Lino Graglia believes really there should never reverse an action, or as Lino puts it, they never would actually. The Congress or the legislative branch really can't pass an unconstitutional law. They would never pass an unconstitutional law. Therefore, there's never any reason for the judges to invalidate the law. Lino represents the judicial restraint part of this coalition that is in tension with the originalist part of the coalition. This tension, which was fully revealed in the Affordable Care Act case, in which you really had 4 justices who were prepared to reach the result that was consistent with the original meaning of the Constitution, although it wasn't an originalist analysis. The case was never litigated on originalist grounds. There was clearly a gravitational force being pulled by originalism in the direction that 4 justices were willing to do that, but 1 justice notwithstanding the fact that he conceded the correctness of the argument against the constitutionality of the Affordable Care Act, nevertheless adopted what he called a saving construction, which changed the meaning of the provision, Section 5000A of the Affordable Care Act, from a legal requirement or mandate, which he said was unconstitutional, to an option, either buy health insurance or pay a fine, or pay a tax, not a fine, actually not a punitive tax, but just a tax. And because it could be reconstrued in this way that was not its natural meaning, it could be upheld under the tax power. But what was the justification for that? What would be the big picture justification for that? It would be judicial deference. It would be doing everything you can, bending over backwards and into a pretzel, so that the unelected, lifetime-appointed judiciary were not going to invalidate the laws that were passed by what the president referred to as a strong majority of a democratic of the democratic branches, the more democratic branches, a strong majority of, let's say, 3 votes. So we now saw what happens when there is when the tension between one strand of judicial conservatism, or the types of judicial philosophy that animates the Federalist Society coalition, comes in conflict with the other part. And in this case, one of the justices opted to break ranks from the more originalist inclined justices in this particular case, and adopted the restraint position to many people's dissatisfaction amongst our coalition, thereby engendering what I hope will be a very healthy debate on the merits of one of these strands of our thinking versus the other strand of our thinking. And fortunately today, we've assembled a very engaged panel who have done a lot of thinking about these issues. It's not just a panel that we've asked to think about these issues for purposes of this program, but this is a panel where people have already done a lot of serious thinking about this question. We have a conference call, as we always do, in planning this session, so I have an idea of what each panelist is going to contribute, and it's going to be a very balanced and thoughtful panel, which I'm not going to waste the time of giving you extensive introductions. I'm just going to tell you the order in which they will speak and the format that we're going to follow. Well, let me tell you the format first, and that is that they're going to give 7-minute talks to outline their position, basically just state their position. There'll then be some interaction amongst the panelists as it seems appropriate, and then we'll open this up to a discussion with you as soon as we can, because this is a subject about which everyone in this room already has an opinion. That opinion is a knowledgeable one, and one that I think is best engaged as a discussion rather than a talking to, rather than a lecturing. This is not one of those panels where you came here to be informed of some technical matter like Dodd-Frank that you may not know about. This is something you've all thought about and can participate in. So that's my goal as moderator, to get this to you as quickly as possible. So with that in mind, let me just give you the order of the speakers. I'm not going to make any introductions besides their affiliation. Going first is going to be Josh Hawley of the University of Missouri School of Law. Going second is going to be Elizabeth Price Foley of the Florida International University College of Law. The third speaker will be Lee Strang of the University of Toledo College of Law. And then finally, probably because he wasn't on the conference call and so he got the last pick, is Chris Green of the University of Mississippi School of Law. And you're going to see that what they present to you is going to be a pretty equally balanced assessment of how this tension ought best to be resolved. So with that in mind, Josh, you're free to go first. You're free to speak up here, or you're free to stay where you are.
I'll just stay right here, if that's all right. I'd like to approach the question a little bit indirectly by revisiting an episode in American history that I think is often overlooked, but which in fact reveals a good deal about the nature of our constitutional order and by implication the judiciary's place within it. And so I think bears directly, as it turns out, on this question. And I'm talking about the so-called Revolution of 1800. The contested election of 1800, which ended, as you may remember from your American history, with an election by the House of Representatives, where the House finally, after 35 ballots, chose Thomas Jefferson to be president over Aaron Burr. They had received the same number of votes. The Revolution of 1800 is significant for at least 2 reasons. One is it's the first time in history that political power passed peaceably from one organized political party to another. Never happened before. And secondly, more to our purposes, it's also the first time that the citizens of a republic settled a major question of constitutional interpretation by an election rather than by revolution. The Revolution of 1800, the election of 1800, more aptly, or more exactly, represents a form of constitutional interpretation by public election, which I think is something that is quite key, as it turns out, to our system, and I'll come back to that. Let me just set the stage a little bit, talking about the crisis of 1800. It had its origins in the political controversies of the 1790s, and again, you may remember what some of these are. Could the federal government charter a national bank? Could the federal government assume and manage a national debt? How powerful could the presidency be? Who would control United States foreign policy? Would it be Congress and the Senate, or would it be the president? These controversies, I think, are noteworthy, and they became crises for two reasons. The first is that they are quite fundamental. That is, they implicated questions not just of what you might think of as ordinary politics, but they implicated constitutional questions, questions of constitutional principle, regime-level questions. Were we going to be a capitalist democracy, a la Alexander Hamilton, or were we going to be an agrarian republic, the vision of the Jeffersonians? So fundamental regime-level questions implicating fundamental constitutional principles. That's the first thing. The second thing, noteworthy thing about these controversies and why they became crises is that I think they were unexpected. The framers, when they wrote the Constitution and then when it was ratified, anticipated that great questions of regime principles would be settled. I think it's difficult to read the record of the debates in Philadelphia and not come away with the impression that American politics after the ratification of the Constitution would consist of mundane, sort of administrative matters, how to organize the militia, where to set tariff imposts, and so forth. But that is, in fact, not what happened in the 1790s. We had the sudden emergence of very serious, very fundamental, even radical disagreement about basic constitutional principles and the direction of the republic. And this proved to be quite a surprise, and an unwelcome surprise to the founding generation. So by 1800, we had political actors in the country at large confronting two starkly divergent visions of the Constitution and of constitutional government. And here was the problem. There was no clear way to settle the dispute. How were they going to decide between these competing interpretations of constitutional principle and competing visions of constitutional government? And that is why the Federalist-controlled Congress, for 35 ballots, refused to ratify what was the fairly clear choice of the public, more or less, namely Thomas Jefferson as president. For 35 ballots, they refused to give the presidency to Thomas Jefferson because they were convinced that Jefferson represented a subversion of the Constitution, or that his positions would subvert the Constitution. So this is how radical and fundamental the disagreement was, and how unclear it was to the actors how to settle it. Of course, eventually the Federalist-controlled Congress did give way under threat of armed conflict, as again you may remember from your American history. And it was Thomas Jefferson, upon assuming the presidency, who realized that this crisis and its resolution, revealed something very important about the American constitutional order. And the first thing is that the Constitution, the written Constitution, actually settled far fewer things than the founding generation initially supposed. It left open a great many more questions of constitutional principle than they initially thought it might. And the second thing is that these constitutional principles, these open questions, required constitutional interpretation. So in order to make the Constitution that the framers had written effective, it had to be interpreted. And that public election, Jefferson saw, could be a form, the principal form, of constitutional interpretation. Public election is how the American people would choose between these competing, radically different, in some cases, versions of constitutional interpretation and different visions of constitutional principle. And so Jefferson concluded that, in fact, constitutional interpretation by public election would stand in for the right of revolution that the people enjoyed from the state of nature. So public election and constitutional interpretation via public election for Jefferson became quite central, became very important in his analysis and understanding of constitutional democracy. It's how the American people remained sovereign in the constitutional system, it's how they exerted their control over constitutional government, and it's how they became full participants in constitutional democracy. And I don't have time to defend this, I just want to assert to you that in fact this tradition, or this practice, of constitutional interpretation via election became quite central to the American political tradition. In fact, in many respects, it is the American political tradition. And that it has had very healthy and laudable consequences and implications over the years. It has contributed to the deep public respect in which the Constitution is held. It has contributed to a unique form of constitutional democracy, constitutional self-government for which the United States has been known, and it has also been an extremely effective way to operationalize our written Constitution. So I want to point out at this point that this practice of constitutional interpretation by the public depends on a distinction between constitutional law on the one hand and what you might call constitutional politics on the other. Now, this is different from ordinary politics. You might have ordinary politics, you know, how high should taxes be, etc. But constitutional politics is the question, what do constitutional principles mean? How should they be cashed out and how should they be applied? And Jefferson's vision, which I think is a healthy one, and is how the Republic basically worked until the last 50 years, is that constitutional politics was the province of the American people, not the Supreme Court. But what we've seen in the last 50 years in particular is the Supreme Court wading further and further into constitutional politics and steadily reducing the scope of the people's discretion in this field and arrogating those decisions to itself. And I just want to suggest to you that this has been an extremely unhealthy development. It has led to all sorts of democratic dysfunctions that you're probably familiar with. And we can talk more about the application for this point later in the Q&A and among ourselves. Let me just suggest now as I close that at least one implication for this story and the lessons of 1800 and thereafter is that judges should not only confine themselves to the text of the Constitution, but they need to approach their constitutional interpretive duties with an attention to the difference between constitutional law and politics and to the structure of our system that permits the people a large say in the resolution of contested constitutional norms. I'll leave it there, and hopefully we can flesh that out more in the Q&A.
Well, Josh, thanks so much for that, and we will flesh it out. I think everybody here is going to want to hear more about that as well, and thanks for also sticking within your time so well. So, Elizabeth.
Okay, I'm going to try to stick in my time too. 7 minutes is not much time, but I was thinking about the title here, Judicial Deference versus Judicial Engagement. And we know these are fundamentally different approaches to judging. And traditionally, of course, when we think about these two phrases, we think judicial deference, we think conservative judges, right? Because they've embraced deference, they're the standard bearers of judicial deference, and they do it because they're afraid of the label activism. And then we think about the other label, judicial engagement, and we're more likely, of course, to think of liberal or progressive judges when we think of that, because they've really been unafraid to embrace engagement, especially, at least in the realm of individual rights, when it comes to certain sort of favored rights that they want to recognize via constitutional law. And so this is pretty much the game we have today, if you will, in constitutional cases. But there is a growing sort of cadre, I would say, of scholars and judges, more the former rather than the latter, who believe that this traditional battle cry of deference is in fact not only not constitutionally required, it's all made up by judges, but in fact it's downright dangerous to the Constitution and in particular to the Constitution's original meaning. And I'm going to give you an example, I think the most frightening example I've seen in recent years of the danger posed by this sort of reflexive deference in constitutional cases. And believe it or not, it comes from an odd source. It comes from something probably most of you read recently, an op-ed in the New York Times on December 31st by Mike Seidman, Georgetown Law School. And it was titled, "Let's Give Up on the Constitution." Well, you know, that caught my eye right away. And after I had a little chuckle and then got really angry after I read it, I said, you know, I want to talk about that in my 7 minutes. And I'm sure Professor Seidman didn't come up with the title, but the title nonetheless accurately reflects his position in that particular op-ed. And his position was unusually honest and straightforward and frank, but it was essentially typical of what you'll find from liberal and progressive constitutional scholars today, at least their approach to the Constitution since the New Deal. And of course, here's what he told us, and we all know this story, right? He proclaims, first of all, a need to, and I'm going to quote him here, quote, "extricate ourselves from constitutional bondage so that we can give real freedom a chance," end quote. And so he views the Constitution as this sort of ancient text that sort of is keeping us down and keeping us from real growth and prosperity. It's a hindrance to get past. So if we could only, in Seidman's words, sort of rid ourselves, and I'm going to quote him again, on insistence to obedience to the Constitution with all its archaic, idiosyncratic, and downright evil provisions, end quote, then this country might be able to actually get somewhere, all right? And simultaneously, after he sets forth this vision of, sort of getting rid of the Constitution, he declares that this is not to say that we should disregard or disobey all provisions of the Constitution. Well, that's got to make you kind of wonder for a second. And he goes on and identifies certain constitutional provisions that he thinks are still sort of entitled to some respect. He identifies free speech and religion, not surprisingly because he's progressive. He identifies equal protection and due process. And he says that we ought to continue to adhere to these ideas, not out of some sort of obligation, but merely out of respect. I'm not sure where he's getting that from. But then he also tackles some structural provisions of the Constitution, which I thought was rather interesting. He mentions the bicameral Congress. Good for him. I guess he thinks we should still have one. He mentions a 4-year term of the presidency. I thought that was kind of interesting because he mentioned the term of the presidency, but not actually the term limits on presidency. Who knows about that one? But he also thinks that these things should be respected because he says some matters are better left settled. And that's all he says. Okay. So Seidman believes that what has kept this country stable and prosperous over the years is not what he calls a poetic piece of parchment, our Constitution, but in fact entrenched habits and thoughts of the people. It's just that we're good people. We're a democratic people. We're sort of an advanced democracy. So we could be trusted to keep the railroad running without this crazy Constitution that keeps standing in our way. So we should be more like Great Britain, Seidman suggests, and we do quite well without the shackles of a written Constitution. Well, to me, this is very disturbing, this approach to the Constitution, especially the fact that the guy makes a living teaching constitutional law. But his vision is the liberal and progressive vision that dominates constitutional thinking and constitutional litigation today. We have a default position of judicial deference to government power. It manifests itself in modern rational basis review. And then there's this sort of asterisk or a footnote that says, well, we'll do rational basis review except when certain rights we favor are involved. Right? It doesn't matter whether these rights are enumerated or unenumerated. As long as we like the rights well enough and they're important enough to us subjectively, we're going to tick up the level of judicial scrutiny from rational basis review to heightened scrutiny. It takes the form of intermediate scrutiny, strict scrutiny, and I would contend also this rational basis review with bite thing that we see pop up from time to time. And conservatives fear this, so they fear being labeled activists. So they've wholeheartedly embraced this entire rubric, this deference in constitutional cases, and they've generally eschewed the use of heightened scrutiny, or certainly they've tried to limit it or prevent its expansion in any further cases. And frankly, I think this is a complete and utter mistake that conservatives have made. I think we've been outmaneuvered. I think this reflective deference, not only isn't it constitutionally required, frankly, it's contrary to the text of the Constitution in many respects, at least in individual rights cases. It's completely contrary to the language of the Ninth Amendment. And it, more importantly, I guess, has slowly eroded the constitutional architecture because what it's done is had aggrandized government power and also parsimoniously protected only a certain few fundamental rights. So it's really left us in a mess. So what's a conservative judge supposed to do, right? Well, I think we need to become more engaged and not be afraid of the label. And in my Mason piece, and by the way, if you guys haven't seen the George Mason Symposium issue last spring on judicial engagement. If you're interested in the topic, look at the whole symposium issue. It's fantastic. But I explore one possible small step we could take as conservatives and libertarians toward the goal of becoming more engaged. And that is to jettison modern rational basis review and not be afraid to do it. But we wouldn't have to do it in a in-your-face kind of way because all we'd really have to do is just revert to old-school rational basis review. And I use old school just because it's easy for me to remember. Well, what it means is pre-New Deal rational basis review that we had basically for the first 150 years of our republic. I used the case of Nebbia versus New York from 1934 as my example in the piece, but you could pick a lot of other cases that would work just as well. And what this old school rational basis review would do is essentially require the government to actually prove something. Not a lot, frankly, still. But prove something. Prove that there's a legitimate purpose behind the law. That won't be hard in most cases. They just say public health, safety, something like that. But more importantly, they'd have to prove a real and substantial relation to that purpose, that there'd have to be some close fit between the means used and the purpose they're articulating. And that would basically turn judges into something more than a rubber stamp. They would, in fact, then be required not to put their thumb on the scale of the government, but to even things out against government power and in favor of the citizen. It also would allow judges to actually use and uphold their oath to support the Constitution under Article 6 of the Constitution. So that's just one example, but I think there are many others that we could talk about along the way.
Thank you very much, Elizabeth. For those of you who ever want to read an example of how that review looks like in the modern context, you should read the lower court decision in Williamson v. Lee Optical and see how the court how the three-judge panel there did evaluate the statute before it went up to the Supreme Court, who argued that a hypothetical rational basis was all that was necessary. There in the lower court, they use a presumption of constitutionality but argue, what is this statute rational, or is it in fact arbitrary and discriminatory? And they find that it is by evaluating how the statute actually operates. So if you want to see just how it's done, as opposed to just how a law professor might say it should be done, if you read the lower court opinion in that case, it's kind of an interesting examination of how the method works. Next up is Lee.
Thank you very much, Randy. Thanks to the Federalist Society for organizing this conference. I look forward to it every year. And I appreciate John's introductory notes about Judge Bork. I know when I was in law school, Randy's book hadn't come out yet, so I read Judge Bork's books before I took my constitutional law classes, and they were influential in my own views. My thesis this afternoon is that originalism requires judicial deference in some situations, but not in others. In particular, I'm going to argue that the Supreme Court should exercise independent judgment, no deference, in the context of constitutional interpretation and when the legislation in question conflicts with an originalist precedent. Second, I'll argue that the Supreme Court should defer to legislative judgments in the context of constitutional construction and in the context of a non-originalist precedent being on point. Given my time limits, I'll just be descriptive. I've written about this further elsewhere, though. My comments this afternoon hinge...
Could you just tell us, everybody, where you've written about it so that he can find it easily?
The one article was Fordham Law Review, Virtue Ethics and Originalism. Another was two pieces on originalist theory of precedent, one in BYU and one in New Mexico Law Review.
Thanks.
So my comments this afternoon hinge on a distinction between constitutional interpretation and constitutional construction, and there's been a lot of discussion, many people in this room contributing to those concepts, including articulate dissenters, of there being such a distinction. For my purposes, and assuming that such a distinction exists, constitutional interpretation occurs when the Constitution provides a determinate answer to a constitutional question. A communist dictatorship is determinatively not a Republican form of government. Constitutional construction, by contrast, occurs when the Constitution does not provide a determinate answer to a constitutional question. I think that legislative malapportionment will be a situation where the Republican form of government does not determinatively say whether that type of malapportionment is a violation of the clause. The second distinction my comments hinge on is a distinction between originalist and non-originalist precedent. Originalist precedent, I've argued elsewhere, is a precedent that correctly articulates and correctly applies the Constitution's original meaning, and a non-originalist precedent incorrectly articulates or incorrectly applies the original meaning. So first, constitutional interpretation. In the context of interpretation, the Supreme Court should not defer to legislative constitutional judgments, because the Supreme Court's case-deciding power granted in Article 3 requires federal courts to use their own good faith and their own best efforts judgment regarding the Constitution's original meaning. There is little or no constitutional text, structural principle, or historical evidence that suggests in doing so the Supreme Court should not utilize its own best judgment. And instead, I think the justices would violate their oaths were they to defer to the legislature's differing constitutional judgments. And I think this is a widely held view among originalists today. And typically, the arguments that are given for deference in this kind of context are ones that wouldn't be persuasive to most originalists. So, for example, Pam Carlin, in her recent Harvard Law Review Forward, argued that the Supreme Court should defer to democratic judgments for textually unmoored constitutional values like liberty, equality, opportunity, and inclusion. But the second area where the Supreme Court should not defer, I think, to legislative constitutional judgments is when the particular statute or legislative action falls within the scope of an originalist precedent. Because the originalist precedent establishes how the Constitution's determinate meaning governs a particular factual scenario. It properly articulates and applies that meaning. The original meaning of judicial power requires federal judges to follow this originalist precedent over a contrary legislative judgment unless and until that originalist precedent is overturned. Now, there are a lot of nuances to this claim that I can't get into here. For example, whether the originalist precedent is one that's relying on metaphysically or epistemically determinate original meaning and some consequences that flow from that. In the constitutional construction context, however, I think things are different. That's where the Supreme Court should defer to legislative constitutional judgments. And there, in the literature, are a number of commonly cited reasons for this. Let me just briefly mention three. First, since we're in the context of constitutional construction, the Constitution has not determinatively answered the question posed by, for example, a constitutional challenge to a federal statute, and therefore the originalist justification for constitutional judicial review is inapplicable because there's nothing in the Constitution that contravenes the legislative judgment, and therefore nothing in the Constitution that authorizes the Supreme Court to displace that legislative judgment. And so instead, the Supreme Court should defer to the construction adopted by Congress. Second, Article I grants Congress the primary power to make decisions for the common good within the scope of its enumerated powers, of course. And so absent a constitutional violation, Article I provides that Congress's judgment is determinative and should therefore receive judicial deference when Congress constructs constitutional meaning. A third argument is that absent a compelling reason, in our society most people believe that democratic choice should govern. And in the construction context, Congress's democratic construction of a constitutional meaning has a relatively greater democratic pedigree than the alternative and should therefore receive judicial deference. Now, the position I just articulated, that the Supreme Court should defer to constitutional judgments in the context of constitutional construction, is not the only originalist position, although I think, frankly, it might be the most common one now. For example, Randy has prominently argued that the Ninth Amendment is a textually required rule of construction in the construction zone. The second area where the Supreme Court, I think, should defer to legislative judgments is in the context of a non-originalist precedent. Article III's judicial power requires federal judges to overrule non-originalist precedent, subject to, I think, to some qualifications that aren't important here. A congressional judgment to the contrary to a non-originalist precedent, provides the opportunity for the Supreme Court to overrule that non-originalist precedent. And so I think, though the practical effect of overruling the non-originalist precedent is judicial deference to a congressional constitutional judgment, it's actually the Article III obligation of federal judges to follow the Constitution's original meaning that's doing the work in these cases, and not a freestanding doctrine of judicial deference. So what I've argued is that the Supreme Court should not defer in context of interpretation, and when there's an originalist precedent, it should defer in the context of construction, and when there's a non-originalist precedent. And so the conception of originalism that I've detailed, I think, continues to embrace the character of judicial restraint that's been a facet of originalism since Judge Bork first articulated originalism over 40 years ago, though I think in a narrower role than what the conception that he had utilized. Thank you.
Wow, that was less than 7 minutes, Lee. So that's
6 minutes.
We're going to give you some. We're going to reserve the balance of your time, or for rebuttal, I suppose.
I thought you might give it to me.
Okay, Chris, you're up next.
Well, thanks for the chance. Is this sufficiently on, I guess? Thanks for the chance to be a part of this panel. I thought I'd talk about a couple of developments from the philosophy world over the last 20 years that I think shed some helpful light on the topic of judicial power. It's emphatically the province and duty of the Judiciary Department to say what the law is, says Marbury. The basic idea is that judicial review is the making of an assertion. If it is, then it should be governed by the rules that normally govern assertions. So the two developments from philosophy land that I have for you are the idea that knowledge is the norm of assertion, which has become quite popular since Timothy Williamson's work on the subject in a 1996 paper and his 2000 book, and the interest sensitivity of knowledge, which has become pretty popular since the work of Keith DeRose in 1995 and in books by John Hawthorne in 2004 and Jason Stanley in 2005. Have any of you heard of any of those people, I'm wondering? One of you, okay. Know your audience. Now I know my audience, okay. So knowledge as the norm of assertion. The idea is that if you're asserting something, you should generally say what you know, but stick to what you know. If someone makes an assertion, it's normally proper to ask in response, how do you know that? If someone asks me a multiple choice question and has answers yes, no, and I don't know, then usually those answers are both exhaustive of the possible replies as long as a reply is reasonably expected. And they're non-overlapping. Okay, so if I say yes, I'm ordinarily not tempted to also say, I don't know. If I am willing to say yes, well, that means I do know. Okay. On the other hand, if I do know, so I don't want to say I don't know, ordinarily I'd be willing to assert and answer yes or no. Okay. Second idea, the interest sensitivity of knowledge. How much we have riding on a proposition will determine whether we know it. More at stake means that the knowledge honorific requires more evidence, and if we accept knowledge as the norm of assertion, assertion requires more evidence. So the standard example from philosophy land is the bank is open on Saturday. So it's 2 p.m. on a Friday. It's a great time to tell this illustration. So it's Friday. I'm thinking of going to the bank, but I've got other things to do. So if I know that it'll be open tomorrow morning, I'll wait till then. So if I need to go to the bank to get cash for a poker game Saturday night, that's a low-stakes context. So if I vaguely recall seeing some cars at the bank a month ago, that would be good enough. Yeah, I know the bank's open on Saturday. But if I need to get to the bank to deposit a check to avoid a mortgage default on Monday, I don't know. Okay. If the stakes go higher, you can lose knowledge because you don't satisfy the higher standard. Okay. So I want to combine these two ideas into a philosophically informed judicial activismometer with 4 levels. So this, you are witnessing, I hope, the birth of a word, activismometer. So there's 2 ways to breach the norm, the knowledge norm of assertion. You can make assertions about the law while remaining confessedly agnostic about critical facts, or you can refuse to make assertions even about matters that are able to be known. So these are levels 1 and 4. Level 1 is, if a court has jurisdiction to interpret the Constitution, too passive, because a court remains silent in the face of known or knowable constitutional problems. Level 4 is too active, because it makes assertions contrary to the elected branches, even in the face of agnosticism about critical facts. In between these, we have courts that accept knowledge as the norm of assertion, but see judicial review as a relatively high stakes or relatively low stakes proposition. So these are levels 2 or 3. I mean, really a spectrum on my activismometer. Level 2 says that we should only find a constitutional violation as judges if it's clear, for instance, or only if an issue is beyond reasonable doubt. Level 3 would say that we should find a constitutional violation if it's shown, say, by a preponderance of the evidence. So here are 4 level 4 mistakes. Justice Jackson in Youngstown said he couldn't assess historical materials on executive power, but he still struck down the Steele seizure. Roe didn't know the status of the fetus and contradicted Thompson violinist arguments, but still struck down abortion laws. Perry and Windsor, the recent gay marriage cases, claimed agnosticism. They said we're going to sidestep this issue. They claimed agnosticism on the superiority of heterosexual child-rearing environments. But given the sort of social meaning dilution analysis common in trademark cases, I think such agnosticism conflicts with Perry's denial of a legitimate interest in preserving traditional social meanings and with Windsor's claim that sexual orientation classifications tend to be arbitrary. James Bradley Thayer's famous argument confuses, I think, levels 1 and 2. He takes statements of relatively high standards of proof concerning constitutional issues, and he changes them into the idea that courts are not actually directly inquiring into constitutional meaning. That's something only the legislature does. Courts, for Thayer, only consider a separate, lesser, easier question of whether a legislature has gone beyond reasonable limits. And interest-sensitive epistemology, I think, offers a non-Thayerian interpretation of these doctrines, limiting judicial review to clear constitutional violations. They establish not 2 different questions for legislatures and for courts, but one question with 2 different standards of proof. The existence of a high standard not easily met is not an excuse to fail to conduct an investigation to see if the standard can be met. It's one thing to say that a court should not act if it cannot amass a significant amount of evidence of unconstitutionality, but it's another thing entirely to say it should not even try. O'Gorman, it's a 1931 case. I think it similarly confuses levels 1 and 2. It turns the presumption of constitutionality into an exclusionary rule, eliminating any adverse inference from the government's failure to proffer a factual basis for a law. So it's sort of like a Griffin versus California or Doyle v. Ohio for the government. McDonald v. Chicago, their treatment of the Privileges and Immunities Clause, I think, is another level 1 error. Academic disagreement, which they point to, I don't think is a proper excuse not to try to assess constitutional meaning. Thanks.
Well, thanks you, all four of you. And so rather than ask you now to respond to each other, because you've basically only been able to state your positions, before we open this up to the audience, to the group, and I think you're going to have to stand at the microphone since we're recording this program, I thought I would just ask each of you a question, a hopefully critical but helpful question that may be in the minds of the audience already, starting in order, so with Josh. So, Josh, my question for you is, how, if at all, does your approach, which you only really had a chance to almost bring us up to and not quite present, so you should feel free to present if you need to, how, if at all, does your approach differ from Bruce Ackerman's views on the relevancy, for example, of constitutional moments in which electoral politics has dictated what he considers to be an amendment to the Constitution? Some amendments are properly ratified under Article 5, but other amendments are not proper Article 5 amendments, including, for example, maybe even the 14th Amendment and the way it was ratified, and certainly the New Deal Court, New Deal Amendment. So how does your view of constitutional politics compare with his more familiar view?
Yeah, I would say that unlike Bruce Ackerman, I actually believe in the text of the Constitution and think that it does have real content, and that when that content is determinate both in its core meaning and in its application to constitutional questions before the court, that the court should apply it. So actually I think the rubric that Lee referred to and traced for us, and that Keith Whittington, others including yourself, Randy, have developed between constitutional interpretation and constitutional construction is actually very helpful, I think, and I largely agree with. My own view is that constitutional construction, or the areas of constitutional meaning that remain to be constructed, are relatively large and probably outweigh or larger than the areas where there is a determinate constitutional meaning and a determinate application for a particular constitutional question. So I would say that where the Constitution's text has a determinate meaning and its application is relatively determinate, sufficiently determinate, something like maybe level 3 that Chris was talking about. In that case, the court is perfectly within its proper authority to act and to invalidate, if necessary, legislative action, and it does not owe deference, more importantly, to the legislative branches. But my overarching point is I think that the bounds or the area, the rubric or the space of constitutional construction is actually quite large, and that moreover there may be areas where the court, where questions are close, there are possible constitutional applications, but the court needs to be sensitive in reaching a constitutional judgment, and especially in invalidating laws. It needs to be sensitive to the ability of the legislative branches and political branches and the people more broadly to continue to participate in constitutional discourse. So this is something like a meta-norm that I think the court ought to approach its constitutional adjudication with. That is, it ought to be asking itself, are ample channels for public participation in resolving contested norms still available? And so it should be very certain that constitutional meaning is determinate and that the application of the meaning is determinate before it acts against the political branches and against the meaning that has been reached by the people's representatives.
Thanks. That was highly responsive to the question. Elizabeth, how do you respond to the objection that judges are not competent to second-guess legislative judgments using any kind of enhanced scrutiny, even of the kind you describe as rational basis scrutiny, and, moreover, to do so, or to attempt to do so, is to exercise a legislative as opposed to a judicial function and is therefore outside the proper province of the judiciary?
Well, I mean, I don't understand, frankly, why people think judges aren't competent. We do it all the time. This is what judges are designed to do. Somebody has to construe the Constitution, particularly in the realm where it is vague. And we know that there's a lot of important provisions like that. So somebody has to do the heavy lifting. It seems to me that the judges have a role in that, and that the rules of construction which should guide them are actually provided by the constitutional text itself. When you're looking at constructing the scope or construing the scope of government powers, you should be guided as a judge by the structure of the Constitution, which is a structure which is clearly one of limited and enumerated powers only. And gives the great residuum to the states respectively or to the people. That suggests that there should be a general presumption against government power. And when we're construing individual rights, I think your rule of construction comes from the 9th Amendment rather than the 10th Amendment. And that should suggest that, in general, there should be a presumption of individual liberty against government power. And what level of scrutiny you then want to make up to go along with that, whether it's strict scrutiny, intermediate scrutiny, rational basis review of bite, or what have you, is, I think, to some extent, a judicial choice, and that's really what we're talking about. What is the right judicial choice? Remember that just because you give judges the ability to make these decisions doesn't mean they necessarily have the last word. We saw that in Chisholm versus Georgia, where the Supreme Court, construed, the meaning of sovereignty, essentially. And the role of the people, and the people didn't agree with the Supreme Court. They saw the pragmatic ramifications of that, and they immediately passed the 11th Amendment. So, we the people do have some pushback authority, and it doesn't mean that we're giving sort of carte blanche to judges.
Thanks. Lee, my question of you actually channels Josh's response to my question of him. And that is that because the information given by the text itself is in many cases highly abstract and therefore necessarily requires construction, many of the key provisions, the ones we argue about the most in constitutional law, fit this description. Doesn't deference in the construction zone that you advocate as a practical matter, overwhelm these more abstract provisions of the text and render them somewhat nugatory?
Yeah, that's a great question, Randy. And I haven't thought all the way through what counts as a situation when construction occurs, or how a court would respond to construction in every situation. So first thing I would do, I guess I would push a little bit against the characterization that you have of being a large number of abstract principles. I think that's an empirical question, and that it could be the case, for example, that the Equal Protection Clause, which may look at first blush as to be an abstract principle, could in fact be a relatively concrete rule or standard. Even assuming that there are a large number or a significant number of abstract principles, I think that the abstractness could be mediated in a number of ways. For example, it could be the case that for an abstract principle, there is one or more focal cases that abstract provision is meant to eliminate. Contracts clause, we want to avoid debtor relief laws. And then that reading analogously from and getting the information from one or more focal cases, a court could rely on that to abduce further original meaning. So I think there are a lot of tools out there that could be used. I haven't thought that all the way through, though.
I just want to clarify that I sort of resist the term abstract principle when I talk about abstractions, because then it sounds a lot like, for example, the Equal Protection Clause incorporates an abstract principle of equality, which in fact it's much more specific than that. And so I sort of resist that terminology. This doesn't, by the way, undercut anything you said in response. Sure. But I think, for example, the First Amendment is the prohibition on laws restricting freedom of speech is highly abstract. But I wouldn't call it a principle. I would still call it an injunction of some kind. But it's an abstract one requiring an awful lot of constructive build-out before we even know whether a time, place, and manner or whatever, or content neutral or viewpoint neutral. Before we know any of that stuff, that's not in the text itself. But that's just a small terminological point.
I appreciate that.
Chris, my question to you is a little shorter than my questions to the others, and that is, can you translate the four-step or the four-part matrix that you identified for us into a kind of doctrinal recommendation for what the appropriate approach that judges ought to take that would be more recognizable, like, for example, by an actual real-world judge?
Well, parts of it. So certainly, so I mentioned O'Gorman, the 1931 case. And then Caroline Products, sort of, the rational basis stuff is kind of coming out of that. So I mean, the New Deal revolution took longer than, it wasn't all in 1937. But the way I would think of, so one big part of it, I would say court should have a burden-shifting framework for figuring out whether, an infringement on liberty is justified, kind of the way we figure out whether a shooting or a killing is justified. So what do we have? We have a burden of production on a defendant to raise the issue of self-defense. But the prosecutors, the government, still has a duty to prove beyond reasonable doubt that the shooting was unjustified. So this would be a way, essentially, of overruling O'Gorman, or taking a different approach than O'Gorman's take, but not going all the way to an actual presumption of liberty, where the government actually has to prove beyond a reasonable doubt that the law was justified. That would be akin to saying, well, the defendant has to prove beyond a reasonable doubt that it was justified. Well, maybe it was unjustified, so we're going to throw you into jail. So that model, I think, it intuitively seems like one way we could operate.
In your analogy, who's the government here? I mean, it sounds like to me the government is actually the challenger of the statute. Okay,
right,
that's a little confusing.
So the idea is, we have all these statements in like Fletcher v. Peck and some of the earlier cases saying, court should only strike down a law if it's deemed to be unconstitutional beyond a reasonable doubt. Okay, and that's that's our standard from Winship about criminal laws. But notwithstanding that, we still sometimes place a burden of production on the defendant with respect to certain issues. Well, does that violate the presumption of innocence? No, the court says in some cases in the 70s. And I think intuitive, just what the doctrine is in self-defense cases is that the prosecutors still have the burden, and that's akin to the challengers of a law, still have the burden to show that it's unconstitutional beyond a reasonable doubt. But the fact that the government didn't come up, the government defending its law, didn't come up with any factual basis. In O'Gorman, they just said, all insurance agents have to get the same commission percentage. No explanation of what the fact was. That's a highly probative, bad fact about the constitutionality, which the court can use to determine that it's unconstitutional beyond a reasonable doubt.
Got it. All right, so rather than have more interaction, I encourage the panelists to interact with each other in the context of comments or questions they might get from the floor here, because I think that will just spontaneously happen. Does anybody want to go first? Eugene in the back, could you come into the front and use the microphone?
So I remember back to my contracts class, which is the last time I thought about contracts, so I might be quite wrong on this, but a common argument for statute of frauds, there were three common arguments. One was that writings were clearer about what was going on, so we'd know what the party's intent was. A second was the solemnity of a writing made people realize that what they're saying really matters. And the third is the channeling function, that you want to route these decisions into this kind of channel that is most effective. And it seems to me that trying to discern constitutional meaning from supposedly transformative elections suffers from the same problems that oral contracts have, although actually more so. So you could have an election in which part of the debate is about some constitutional issue. Could be free speech, could be guns, could be war power, could be whatever else. But part of it is about something else. Who's going to do the better job on tax policy? Who's going to do the best job on foreign policy? Who's going to protect the country best against terrorism? So it just strikes me as, and of course some of the time also the elections end up yielding a victory for one party in one branch of government and another party in another branch, or in half of a branch, as we've been seeing recently. So I guess I'm wondering how, at least with a constitutional amendment, you've got the text. With a judicial opinion, you've got the text. With a statute, you have the text. You could imagine legislatures deciding constitutional meaning through their decisions, but I take it that's not your proposal. But with the vote of the people, I mean, a historian can come up with a crafty argument many decades later how the election was all about this. The elections that I remember, and that's a limited lifespan, but getting longer every day.
Let's hope so.
I don't remember a single one in which I could credibly say. I mean, I suppose in 1994 now we say, well, part of it was a rejection of the assault weapons bill. I wouldn't want to take that to the bank. So does one solve these problems?
Yeah, it's a great question. I think that the courts have an obligation to defer not to elections, but to the work, the statutes of the political branches of the legislature. So when I said that constitutional interpretation goes on by election, I mean that in the choice of the representatives, and indeed preeminently after 1800 the choice of the president, the American people are involved in choosing between what are sometimes, not always in elections as you point out, but sometimes serious matters of constitutional principle. So in terms of what that means for judicial practice, I do not think, again here to break with Bruce Ackerman, I do not think that that means that courts ought to be looking at election returns and saying, well, in 1940 or in 1994 or what have you. I think the point is that there is a mechanism that our Constitution creates for public participation in constitutional meaning, in constitutional settlement, and in constitutional interpretation.
Got it. So I'm sorry, I misunderstood. But that's basically kind of the, more or less the parliamentary version. Not quite Lino Graglia, to take an example of somebody on the right. There are views like that, just as on the left with Professor Seidman, but close to it. That there are a few things the Constitution clearly has settled, and everything else should be up for the political process to determine the constitutionality of rather than judicial. I'm not saying that to fault that, but I just want to make sure I understand.
Yeah, I think that's right. The question is where are the bounds drawn? So what does the Constitution determinately settle, both in terms of its meaning and its application, and what is open to construction, where there ought to be, where the court should at the least consider the views of the political branches, if not defer to them. And I think that line drawing is the key question.
Okay, thanks.
Come on up, and please, everybody, because it is being recorded, state your name and your affiliation for our audience who will be watching this sometime in the future on a podcast.
Thank you. I'm Brian Fitzpatrick at Vanderbilt Law School. If we put aside for a moment what we think the text of the Constitution has to say about this, and if we put aside for the moment what we think the founding generation thought about this particular debate, I'm curious of the views of those who favor less deference. If we have a constitutional provision, which we all concede is ambiguous as it's applied to this particular case before the court, for example, there's no history out there on this particular question, or the history could be read in either way. There's reasonable people can make different analogies going in different directions. Is there a functional reason why we would want 5 unelected people to resolve the question as opposed to millions and millions and millions of Americans who have elected their representatives? Why the 5 over the millions and millions of Americans? If we put aside text and the founding generation's views, is there a functional reason for the 5? Thank you.
This is a question for Elizabeth and Chris.
Yeah, I can tell that was mine. First of all, I do find it difficult to address your question in the vacuum that you suggested. If I put aside the constitutional text and I put aside its structure and probably, I think, its original meaning as to how it was supposed to be construed, then X. It's hard for me as an originalist to operate in that vacuum, and I'm not sure why I would, frankly. But let me address what I think is more the heart of your question, which is, it came at the tail end, which is why let the 5 unelected Supreme Court justices who comprise the majority have the last word? Again, I think you're presupposing that they do have the last word, and I don't think that they do. I think the way our constitutional structure was set up was that they have the last word in terms of litigation, but we, the people, have the last word. We have the ultimate control of our Constitution through Article 5 amendment process. And the problem is that because we have let the Supreme Court do our dirty work for us for so long, we, the people, have gotten, frankly, quite lazy. We don't know anything about the Constitution. We think constitutional amendments are just too hard. We don't understand them. They're complex. I think we've gotten lazy and stupid. And I think that that's bad for the functioning of our republic the way it was set up. So I think that if we would let the Supreme Court do its job, and then we would let the American people do their job, and we do a better job of educating kids from the time they're knee-high to a grasshopper on up, through including law school, which I think is a real travesty that we only teach constitutional law these days in a one-semester truncated monolithic 4-hour course. And that's most all lawyers get about the Constitution. No wonder we're in this mess. But I think that, you know, you're assuming that they're the Supreme Court's last word, and I just don't think they are. I think they have been functionally, but they're not constitutionally.
Before I turn to Chris, let me just say there's another political check, which, for better or for worse, is real, and that is that justices grow old and they die, and they are replaced. And they're replaced by elected presidents nominating people that have to be confirmed by an elected Senate. And constitutional law will be influenced by those people who survive that political process to become on the court in the future and are capable then of changing or qualifying previous decisions. Chris?
Yeah, I mean, just because you get rid of O'Gorman, you posit a case where it's irreducibly ambiguous and indeterminate. That's a case where you don't know. And if you don't know, if you're a court, you shouldn't say. So that's precisely a case where you do let the people decide. So that, I mean, when you were saying that, I was thinking that's exactly my view.
Well, Chris, in what respect then does your view differ from Lee or Josh's view? Because with that formulation, it sounded to me very similar to the other two views, and it's okay if they are, but it sounded initially that you were taking a somewhat different stance than either of them were taking.
Well, I mean, you have to postulate. I mean, you know, the question is set up with a case where, you know, well, the material is just, you know, they don't resolve the case. If they don't resolve the case, okay, that's one thing, okay. But O'Gorman says we don't have to try to resolve the case, okay. So, I mean, you can think about Justice Jackson's opinion where he says, well, I don't know what the founding materials think, but I'm going to strike down the steel seizure. I think he's wrong both about the existence of the ambiguity and about what to do if it is ambiguous. So I think he's wrong. You can read the Helvidius Pacificus debates and make some sense out of them, okay? But if you couldn't, you should not be doing, you know, you should not be striking down the actions of elected officials. So maybe that makes sense.
I have a terminological question. I think that's what it is. So we hear a lot about interpretation and construction, and I sometimes think I know what that distinction means, and sometimes it eludes me. But is there a third category, which is, this is not a constitutional question at all, this is just the stuff of ordinary politics, so that there's some things that are where you decide that according to looking at the meaning of the Constitution, that's interpretation. You decide some things according to something other than just reading the Constitution, but somehow making sense of the Constitution and building from the Constitution and applying constitutional norms to somewhat disputed questions. And then there are things where you decided according to just reading the statute and seeing what Congress did. Is that right? Or are there actually three? And if so, I'd like to know a little bit more about how you can tell the boundary between construction and just politics.
I would say, given the analysis given by the speaker, by this panel, every panelist should be able to answer that question, or should try to answer that question. So let's just go down the road. I don't know. You want to go first?
Let Lee go first.
Huh?
Let Lee go first.
Okay, Lee. Yeah. Let Lee can go first.
Well, that's a great question, and I think that there probably is a category of just politics in which there is no reasonable claim that something is an interpretation. In other words, Congress is clearly acting within its power. Should the post road go down this road, or should the post road go down that road? That's a political decision based on patronage or whatever it might be. I think, in other words, I think politics could operate within the bounds of the interpretation category, and I think politics could operate within the bounds of the construction category. So I guess I don't know if it is being this is me off the cuff, I don't know if think of it as being a separate third category that doesn't influence the previous two categories or is uninfluenced by those previous two categories. The burden of what I was saying is that politics has a greater role in the construction category in that within the bounds of set by interpretation, politics governs what is going to happen in the construction of constitutional meaning. So I don't know if I can envision there being purely political decisions, but only within these other two categories.
Anyone have anything to add or subtract from that? Chris?
I mean, I guess the standard way of distinguishing construction from interpretation that I've seen is that you've got adjudication or constitutional law, and that's a bigger set than constitutional interpretation. And construction is the extra stuff. So constitutional interpretation plus constitutional construction is just everything you need for constitutional adjudication. How do you distinguish that from politics? Well, I mean, all the stuff I've been saying today is constitutional construction. Because I'm saying this is what you do in addition to working hard at figuring out the original meaning. You need principles about how much evidence of original meaning you need. And I mean, I think going to philosophy land for distinctions is not politics. There might be some politics in it, but I don't know. It would depend on my whole theory of adjudication, which I don't have.
And I would just say that I guess to me, obviously I don't buy into the liberal progressive idea that all law is politics. Constitutional law is very political, but it doesn't make constitutional law politics. They're different things. And it seems to me that the way that judges probably normatively should address these things is they should have rules of construction that guide them. I mean, it's constructions that's doing the heavy work of the Constitution, because that's where all the vagueness is. Those are the hard cases that are so political because they're so controversial. And it's in that realm where we need to have rules of construction. And for many people who are originalists, for example, the way they're going to engage in construction is by reference to original materials. And that's the way they're going to try to go down the path to find the answer. If they go down that path and it yields absolutely no answer, which I can see is going to be the case in many instances, not many instances, but some instances, then I think at that point that's where the rubber hits the road in terms of needing a presumption to do your determination, a presumption for government power or against government power. And when you hit that wall, the presumption should tell you which way you're going to go.
Yeah, and I would just add, I think that in thinking about the difference between construction and interpretation, that I find it useful to think in terms of paradigm cases. So, to me, one current example of a constitutional construction case is whether or not same-sex marriage is a constitutional right. That seems to me to be a fairly classic question of constitutional construction. Certainly constitutional principles and norms bear on that question. Does the text of the Constitution resolve it? I would argue no. Does it resolve it in a determinate way? No, it does not. The legislative veto, on the other hand, the one-house veto may be an example of a constitutional interpretation question, where the text of the Constitution does seem to address the issue. Again, that doesn't mean that there can't be dispute about how the text should be resolved or interpreted, but there is a fairly determinate command there that certainly applies to the question at hand. So that's an example of interpretation where it's not only appropriate but important for the court to rule.
One thing I might add to this, I don't think it's a complete answer to the question that you asked, Mike, but I do think that there are provisions of the text which delegate discretion to various constitutional actors. Like, for example, the obvious case of each House of Congress being able to make its own rules. And there are many expressly delegations of discretion to these various actors, and we might say that, for example, even with respect to the executive branch, a lot of the executive powers are highly discretionary in the way that they are formulated. And if it's the case that the meaning of the text is to delegate discretion to political actors, then I don't know if that constitutes a third category. But when cases like that, because it's not really, because we reach that conclusion as a result of interpretation and possibly also construction. But the end of our inquiry, at the end of our inquiry, our conclusion is that this is a political matter. And that's an inquiry that's arrived at as a result of evaluating the text of the Constitution. And a lot of stuff is a political matter in that sense. Now the question is, for example, is the guarantee clause a political question or not a political? That's something we can debate. I wasn't really thinking about that, but I'm thinking about the express clauses that expressly delegate discretion to political actors, and then those are political. That's a category of political questions that are not judicial.
Craig Hawkins, attorney law school. I have a question, Professor Green. A couple of things. Realize your discussion is, of course, extremely truncated. So what my questions would be, it sounds like in your 4 levels of knowledge, you're assuming a foundationalist epistemology, i.e. justified true belief. You even said just a little while ago, for example, knowledge is not politics. But today in postmodernism, a la Richard Rorty, W.V.O. Quine, and Foucault, they would say it is. I think of Brian Leiter and his use of them at the University of Chicago and some of his work and whatnot. So my question is, those distinctions, are you working those in? Are you assuming one or the other? And how would these impact your views?
The current literature views this as cross-cutting other stuff in epistemology. So Williamson, I mean, he writes an article about knowledge as the norm of assertion, and this is bracketing all of the issues about, you know, is knowledge foundationalist or coherentist? Is it, you know, what kind of justification requirement do we have? What kind of methods do you got to add anti-Gettier stuff. So it's you know, I think I'm intending the presentation to be, you know, completely consistent with any theory. I mean, you have to have a theory of knowledge to go with it, but other than the fact that knowledge is intersensitive, that's, you know.
Appreciate that. And just one more thing. Coherentism would also still be seen, though, many times as a form of foundationalism. So just to be clear, so you're saying, though, that you're saying that it goes across the board with the postmodernist view of epistemology.
Yeah, ordinarily, at least, well, okay. What I learned at Notre Dame was in epistemology, you got foundationalist and coherentist, and those are the 2 views. Well, and postmodernism, you know, Quine is a coherentist.
Actually, the pragmatic holist. Yeah, I realize plan.
Yeah, I mean, holism. I mean, okay. So, but that would be consistent with all this.
Okay, perhaps we'll talk afterwards.
Okay,
you. Appreciate that.
Lee, did you want to go next? Lee Otis.
Hi, Lee Otis with the Federalist Society Faculty Division. So Josh, 2 questions for you, actually. First, why is same-sex marriage a construction case? I think, you know, you could, for example, say that marriage is a privilege or immunity of citizens of the United States, and that everybody is equally entitled to it, and that's an interpretation question. And part of this is I too feel like now I see it, now I don't with construction, I will confess. Second, does it matter that we haven't had constitutional politics going on in a way for some time now, and that people don't know that they can do it? I mean, arguably the Tea Party suggests that people are sort of coming back to realizing they can do it. But, you know, basically when Congress is debating a question where the Constitution is implicated, they tend to think that's for the courts to figure out. And I don't know if Obama thinks that or not, but certainly even presidents have had some tendency to think that's all for the courts. So does that matter?
I think as to the first, why is same-sex marriage a matter of constitutional construction, I think the answer there is because it implicates very fundamental and foundational questions about what the shape of marriage is. So not merely is this institution something that is susceptible to the equal protection norm, can it be defined to be included within the liberty and the due process clause or privileges and immunities, but more foundationally still, and you see this in the public debate about marriage, what does the institution actually mean? I mean, is it limited by its very definition to one man and one woman or no? And that, I think, is an extremely substantive, and as the Ninth Circuit, I think the one part of its opinion that it got right, this is an inherently social, moral judgment, I think. Very, very substantive, very thick, if you like. And one that is simply not addressed by the Constitution. I think that the Constitution simply does not say, and it can't be read to say, what the definition of marriage is or what the shape of the institution of marriage should be. Now, do constitutional principles about equal protection and liberty bear on the question? Oh, I think that they unquestionably do. But I think the deeper more fundamental question about the definition of marriage, I think, is simply not addressed by the text. You want to stop me right there? Okay.
One sort of, so why isn't the answer it's constitutional as opposed to it's a matter of construction?
That is his answer, isn't it?
No, but he's saying that there's some construction involved here, and I guess I'm not sure where the construction is coming in at all. Who's construing or constructing what?
So did you say, why is it even a constitutional matter at all? Was that the first part of your...
Where is what
Ordinary
work is the
politics.
word construction doing here? I'm not seeing any construction going on. What I'm seeing is the Constitution doesn't answer this question, so it's up to the people.
Well, I think because constitutional principles, to use the word Randy doesn't like, or norms of equal protection, liberty, I think that those do, and the discourse that is the constitutional discourse that goes along with them, both public and legal, does bear on the question. I mean, so thus you see in the public debate lots of, not just in the legal debate, but in the public debate, lots of talk about equal protection norms. So I think you do have constitutional norms and values, if you like, that bear on the question. But again, because the Constitution itself does not embrace a substantive definition of marriage, we can't say that it's a matter of mere constitutional interpretation, however difficult. But actually, those norms have to be built out in a way. They have to be extended. You've got to make a judgment about the core normative question and then apply the constitutional norms to your judgment about the core normative question.
If I can help, maybe help you with it, Lee, because I think you're in agreement. I think Josh's position, tell me if I'm wrong, Josh's position is that if this is the realm you're in, if this is the realm of construction you're in that is not being dictated by the actual meaning of the text itself, that should be left to the legislative branches. In your lexicon, it's not something that should be in court. It's something that should be deferred. The legislature should be deciding those matters of what marriage really is. If marriage is a privilege or immunity to citizenship, but the Constitution doesn't tell you what marriage is, that should be given by the legislative branches, not by the courts. Is that?
Yes. Yeah.
May I join back in, because I love Lee's question, independent of how anyone might analyze these things. I think of construction as being different from that. That is, so this view seems to be that the Constitution governs some things, and then everything else is left to politics. So there's it's a dualism. But I take it the construction idea creates a third category that's different from either politics on the one hand, which need not be consistent. They can build their post road through Akron for one reason, and they can go through Charleston for a different reason, and they can change their minds, and it's all politics, right? I took it that construction was something where we do build constitutional principle that then has to be applied in a principled way, but we build it on something more than the mere text. And so, for example, I don't know, the alien and sedition controversy is my favorite example of all of it. So we don't know what the pre-press clause means, or we know what some of it means, but we're not real clear as to whether the specific rigid categories and limits of British common law apply, or whether there's a somewhat broader understanding. Either one might be the freedom of the press. The people debate this in the context of the election of 1800. We come to a conclusion. Jefferson's elected. He pardons all the people who are convicted. The Congress later actually gives back all the fines that were, and so there's been a decision, even reflected in some text, that of one particular thing. And then I take it that that's not politics anymore because it's been decided, and courts will in the future strike down things that are like the Sedition Act, and will then move forward. So there was an act of construction that isn't just politics. It isn't saying that whether or not it's something that was decided politically, but isn't just politics. Is that not right? And so as to same-sex marriage, you might just say, oh, well, the Constitution doesn't speak to that question, so it's all politics. So Missouri can do one thing, and Rhode Island can do another thing, and you might say that this is actually a deep constitutional construction question that we're all engaged in. We don't know what the answer is today, but 2 or 3 years from now, we probably will have resolved this. I have my guess as to how. I personally would just as soon not be decided by people in robes, but I think it's going to be decided. And then we will have something that we're sort of stuck with, that's embedded, that's been, is that not right? So that there's a third, that's why I think there are 3 things and not just 2.
Lee.
Yeah, I appreciate the comments, and the Alien Sedition Act, I think, is a good example for highlighting what I tentatively think is different facets of constitutional construction. So some are more enduring than others. I think the Alien Sedition Act would be an example. So assuming that the Free Speech Clause was originally indeterminate on the question of the Alien Sedition Act, hypothetically, which I think was your hypothesis, the election of 1800, Jefferson's pardons, would have created a construction of the meaning of the Free Speech Clause, one that was durable. And I think that fits, and I haven't worked this into my thought fully yet, that would fit with, and this pushes against somewhat of what Josh had said earlier, the characterization that Josh had of the framers and ratifiers, where Josh's claim, I think, partially was that they had thought they had solved most of the big questions. I don't think that was right. Madison had the famous phrase about liquidating meaning over time, and I think what I take that to mean would be an example that you had gave. The National Bank would be another example where Madison switches sides. People have spoken. That's a durable construction. The Commerce Clause and Necessary and Proper Clause allow for a national bank. So I think I tentatively would work what you're saying into the concept of construction with the concept of durable constructions, or the subset of durable constructions. Josh?
I just wanted to add that I don't think as to durability, however, one of the characteristics of a constitutional construction is that it is not permanent, need not be permanent, is theoretically always open to revision by the political branches. So, has this particular construction proved durable, the Alien Sedition Acts, the particular interpretation of the Free Speech Clause, the Free Press Clause? Yes, it has. Need it be, if it's truly a construction, is it truly locked in? I mean, not necessarily.
I have to bring this to a close. I do want to give my sort of response to this last question as well. I think I agree with your formulation of construction, the way you formulated it. And I think what's happening here is that you're reacting to what seems to be 2 propositions, that whenever anything is construction is political. And the pushback I would give is somewhat consistent with your framework, and that is that if it's this build-out of doctrine of constitutional principles, then that should not be left to the political sphere. That's part of what it means to apply what the Constitution says to actual cases and controversies. But then, going back to my earlier point, there could be the conclusion of all of that analysis which says that based on the meaning of the text, there are some issues that are strictly political. Based on the meaning and how that meaning is properly construed. They're political things like where you build your post roads. That is not something dictated by either the meaning or the proper construction of the Constitution, and at that point it's a political question. But that's a conclusion of the previous 2 forms of analysis. It isn't necessarily a separate form of analysis. It's what's left over when you've done the job under the first 2 categories. But I just want to say I think it's accurate. How you formulated what construction is a nice formulation of it. It's not an incorrect one. I think you've got it. By Jove, I think you've got it. So with that, we are at the end of the session, and the next session is it going to begin promptly at 2:45? Is that right? I'm getting the heads up. It'll begin promptly at 2:45. Thank you, everyone.